Welcome to Lecture 1 of a series of lectures on practical skills for doing social justice advocacy. My name is David Lepofsky, and I will be delivering these lectures. This course is intended to address this topic from the perspective of disability rights advocacy, but what we're going to talk about is equally applicable no matter what social justice cause you are associated with. I'm delivering these lectures in connection with a law school course at the Faculty of Law at the University of Ottawa, but you don't have to be a law student. There's a number of points that I'll make that are law school specific, but all the action tips will be relevant to anyone who wants to do social justice advocacy, to someone who's totally experienced at it or someone who's completely brand new. As you listen to these lectures, feel free to pick and choose between the various action tips and strategies I offer. Think of this course as one big, huge activism buffet with all sorts of things that you can sample, try, improve upon, and come up with something even better than what I have to offer. I welcome feedback on this course. I welcome feedback on anything I have to say. Feel free to email me at aodafeedback@gmail.com. Now, there are good things to read in connection with these lectures. They will be useful even if you don't read them, but if you do read them, well, there's just that much more that'll be available for you. In connection with this course, I invite you to read a memoir that I've written called Swimming Up Niagara Falls. It's about the battle to get disability equality enshrined in the Canadian Charter of Rights and Freedoms back in 1980. The good news about that memoir is it's free. You can download it in Microsoft Word format or PDF or EPUB, or as an audiobook by going to www.aodafalliance.org/publications. I invite you to read the writings of Saul Alinsky, a social justice activist from the 50s and 60s, especially the book Reveille for Radicals. It's my Bible and has been for decades. And finally, I invite you to check out my podcast. I have a podcast that focuses on practical action tips and strategies for social justice advocacy using the disability advocacy experience as a basis. It's called Disability Rights and Wrongs, the David Lepodcast. It's available wherever audio podcasts can be found. At the time of recording, it's not on YouTube, but it's on Apple Music, Spotify, Amazon Music, and so on. Now, what are we going to talk about in this first lecture? I'm going to outline some core themes that'll be covered and that'll cut across all of these lectures. Tell you a bit about me. I'm going to talk to you about the ethical duty of lawyers to engage in social justice advocacy. So for law students and lawyers, this will be informative, but for everyone, there's certainly perspectives to gain from. I'm going to talk about why this kind of advocacy is legitimately core lawyering activity. Again, it's important activity even if you're not a lawyer, but it's something which certainly is core to what lawyers do, even though a number don't. So let me move now to core themes across these talks. When you engage in this advocacy, you are always trying to build and reinforce your credibility. You're doing it on four fronts, often at the exact same time. Credibility with the community for whom you're doing advocacy, credibility for the people you're advocating to, whether it's government or others, credibility in the eyes of the media, because you'll be seeking coverage from them, and credibility in the eyes of the broader public, the general public, because ultimately, in a democracy, you want the public on side. It's not something you do just once. It's something you work on constantly throughout all your activities. And I'll provide practical suggestions of how that could be done. You are always advocating. This isn't like a lawyer who just goes in the courtroom and does their advocacy thing and then goes home. This is the kind of thing that you are engaged in advocacy all the time. And indeed, at times when you least expect it. Stay tuned for illustrations of this. Well, when you argue cases as a lawyer, sometimes you can tell which argument won the case. You get reasons for judgment, and there it is. You made the argument, it decided the case. Doing social justice advocacy can be very different. You may never know which specific point you made, which specific strategy you used, which specific interview you gave that may have turned the tide and made the difference. There may not be one specific thing. It may be an accumulated impact of all of the action tips that this course will focus on. Core to my message to you is be unorthodox. Don't just do what other people have done. Come up with new ways to do things. I personally love being plagiarized. So feel free to borrow any of these action tips, even turns of phrase that you see in these lectures and the supporting materials that you can read in connection with them. And I don't want credit. I'm happy if you use them and if they become just part of you and part of your advocacy message. Please feel free to plagiarize. What I've found doing any of the kinds of things I'm going to talk about in these lectures is that the individual activity becomes your sole focus. You're planning an event, you're unleashing a particular strategy, you're focusing on a particular piece of legislation or whatever. And it becomes all-consuming with a very specific target, short-term target in mind. And that's the way you got to be. But then when it's all done, whether you're successful or not, I find that afterwards, whatever you did has all sorts of side benefits, ones that you didn't think of, ones that you didn't work on, ones that you didn't plan for, ones that you could not have foreseen. So get ready for seeing activities as useful in themselves and later having benefits that were not part of your calculus at all. Whatever you do, you are not locked into a specific strategy or a specific message. I'm always evolving it. I'm always reconsidering it. I'm always polishing it, and at any time I'm prepared to change it. And this is actually very useful because especially when you're advocating to a big government, we as social justice advocates, we can change on a dime. We can change our strategy, we can refine our message. Large organizations like governments tend to be big, lumbering, and slow. And once they're locked into a strategy, they're not particularly good at changing or turning on a dime. That can have huge strategic advantages. Let me tell you a little bit about me. Not that it's important, but at least if I'm building credibility with advocates and with a broader community, it's worth you knowing whether you see me as having credibility at all. I'm currently a retired lawyer. I practiced law for 33 years in the province of Ontario, working for the Ontario government, doing civil, administrative, constitutional, and later criminal appeal litigation. I retired in 2015, and since then I've been a part-time law professor, working as a visiting professor successively at 4 different law schools, 7.5 years at the Osgoode Hall Law School. At the time I'm recording this, at the University of Ottawa, for whom I'm developing this particular series of lectures, but also the University of Western Ontario and Queen's University Faculty of Law. In talking to you about these tips, I got to tell you, I'm mostly self-taught. I've learned from a lot of people along the way, but there was no course on this topic either when I was at law school or where I got underway. I really wish there had been. I'm always learning. In law, we talk about practicing law, and lay people joke, oh, you're just practicing. Well, in the area of social justice advocacy, whether you're a lawyer or not, You're always practicing. You're always learning. And I'm prepared to change my strategies from one I tried and I thought was great to suddenly say, hey, there's a better way of doing it. From 1994 to 2005, I helped found and then co-led and then led a coalition in Ontario called the Ontarians with Disabilities Act Committee. We fought for a decade to win the enactment of an accessibility law, the Accessibility for Ontarians with Disabilities Act. That coalition was superseded in 2005 by the Accessibility for Ontarians with Disabilities Act Alliance, or AODA Alliance. I've been its chair since 2009, leading advocacy efforts on getting that legislation effectively implemented. For 10 years, almost 11 years, I've been a member of the Special Education Advisory Committee of Canada's largest school board, the Toronto District School Board. You'll hear more about that in a later lecture. And for the past 3 years, I've been its over the past 3 years, I've been its chair. I served from 2018 to 2022 as a member of the Ontario government appointed committee that was designated to come up with recommendations of what an education accessibility standard might include under the Accessibility for Ontarians with Disabilities Act. It's called the K-12 Education Standards Development Committee. You'll hear more about that later as well. And I've also been involved in advocacy as an individual. I've brought a couple of test cases. The one that I guess has gotten the most airplay a couple of decades ago was fighting 2 successive human rights or discrimination claims to get the Toronto Transit Commission to be required to consistently and reliably announce aloud all subway stops, streetcar stops, and bus stops. Let me talk about the ethical duty of the lawyer to engage in social justice advocacy. It is core to law, it is core to justice to maintain, reinforce the rule of law. And the rule of law has many manifestations. It's used often as a cliche, but to begin with, underpinning it are a number of core principles, and one of them is equal justice under law. Now, that sounds like just like kind of universally endorsable cliche, but let's drill down to what it means. What does equal justice under law mean? It means the law applies equally to everyone, but also that everyone can have access to the law to be able to enforce and implement the rights that the law guarantees. As for example, I'm just give an illustration, which is kind of a first-year law school textbook thing that the public knows. We have a court system that is adversarial in nature. The adversary system works on the idea that you've got a dispute, you've got a judge who's going to decide it, and you've got 2 sides to the dispute, 2 parties, whether it's criminal or civil, who are hopefully represented by lawyers who can present all the evidence that can help their case, that can cross-examine and challenge their opponent's evidence, that can bring all the relevant case law and legal principles to the judge's decision. It's the clash of those 2 adversarial or adverse positions that leads to a just result and hopefully the most fair and accurate findings of fact and law. Now, that's all great, but what happens if one side doesn't have a lawyer? One side isn't able to effectively present all their evidence, isn't able to effectively challenge the opponent's evidence, isn't effectively presenting all the relevant case law and challenging the legal argument of the other side? Well, then we not only have a potential injustice in the individual case, but what we end up with is a threat to the very essence of equal justice under law. And if equal justice under law is undermined, then the rule of law is endangered. Now, in an individual case, that's always a bad thing, but if it's a recurring thing when it comes to the rights of a particular disadvantaged equality-seeking group like people with disabilities, then it becomes a systemic threat. It becomes an example or an illustration of social injustice. In law school, law students from the very beginning read cases, often ones decided by the highest court in the land, the Supreme Court of Canada, and debate or learn in class, wrestle with what those cases mean, what their consequences are, how they might be interpreted, how they might apply to different situations, and so on. These are intellectually important and substantively important. But let's look at it through a social justice lens. To get to the Supreme Court of Canada, there's quite an admission price. Not that they charge you at the door, but it costs tens of thousands of dollars to argue a case at the trial level and then argue an appeal and then go all the way to the Supreme Court of Canada. From a disability perspective, most people with disabilities can't afford to do that. Not even close. And so there's a further threat to the rule of law, to equal justice under law, when there's a systemic incapacity to avail a group's rights, to avail themselves of their rights by using the justice system. They may have great rights on paper, but in practice, doesn't really happen. Even if you go all that way, even if you're one of the people who are fortunate, one of the fortunate few can go all the way, and you win, it may not have lasting consequences. The biggest, most powerful decision of the Supreme Court of Canada in the area of equality rights for people with disabilities took place in 1997. The Supreme Court of Canada ruled that under our Canadian Charter of Rights and Freedoms guarantee of equality to people with disabilities, that deaf people have the right to a sign language interpreter funded by the government if they go to the hospital emergency room for emergency services. It's a really important ruling, a really commendable ruling, and has all sorts of broader implications for access to healthcare and other government programs and services. However, years, indeed decades after it was decided, not necessarily clear that in many or in most of Canada's hospitals that right is actually being honored. Great court decision, not a lot of consequence in the front lines of the healthcare system in too many cases. So what do we do about this? And why do I suggest that especially lawyers, but not only lawyers, have an ethical duty to engage in social justice advocacy, to go beyond representing their individual clients that they happen to serve, and to look for more systemic solutions? We in the legal profession are very fortunate. We're fortunate to be trained and equipped in the skill of advocacy. The two core ingredients, being able to delve into an issue and figure out what's relevant and what are the most important arguments, and the skill of persuasion, training in how to take that information and most effectively present it. Issue identification, looking at a problem, identifying what the issues, and then problem solving, figuring out the best way to solve the problem. Now, we're not the only ones who have that capacity and training, but we all have that capacity and training. And it is my core contention that someone who admits themselves to the bar of justice has an ethical duty to admit themselves to the bar of social justice. That could be part of their day job. It could be part of extracurricular or volunteer work outside of their job. As you'll hear in this course, it may involve doing activities as a lawyer or simply using those advocacy skills without necessarily being identified as anyone's lawyer. This could be done through pro bono or individual cases that set a precedent, and that's always useful. But on the other hand, a core way we can engage in this, and what my focus in these lectures will be, is taking our skills, identifying a recurring problem and in the legal system, or that the legal system has not solved, and see if we can find a more systemic solution to that recurring injustice. That may mean fighting for new legislation, like I was involved in, the Accessibility for Ontarians with Disabilities Act. It may be fighting for new regulations, for a new public policy, or some other kind of new practical strategy that actually changes things on the ground. Law school teaches law students how to use the law in the courtroom in like settings. I'm going to talk to you about how to use the law outside the courtroom in other venues of persuasion. And these can, frankly, make as much or even much more of a difference for social justice seeking groups. We are, in this role, social justice advocates and community organizers. It draws on genuine lawyering skills. I'm going to point out at various points how someone who's trained in law will not only have training that can be easily transferred to this context, but frankly, show you how these activities, social justice advocacy, actually can also make you a better traditional lawyer. I will tell you that when I learned to do news conferences and write news releases, they made me, those activities actually sharpened my skills and made me, I believe, more effective at arguing a case in the courtroom and writing a legal submission or factum for a traditional court case. Now, all this talk about lawyering, I want to make it clear, anyone watching these videos, doesn't matter if you haven't gone to law school at all. If you don't have that advocacy training and professional training, there's still lots in these lectures for you. Now, let me ask another important question right up front. Is this advocacy lawyering? Now, you might think, well, I may not be identified as a lawyer. In fact, in all of the activity I've been doing over the past 3 decades in this area, I'm not identified as a lawyer. I'm not counsel to these coalitions. I've been a chair or a co-chair or a member of a group that can advocate for change. Your client or constituency isn't a client in the traditional legal sense. It may be a community, not a incorporated organization, not an individual. Nevertheless, in undertaking these activities, I do my best to follow traditional legal ethics in doing these advocacy activities. I have to make it clear to people I'm not acting as a lawyer. I'm not their counsel. I can't give them legal advice. And what they say to me is not privileged from disclosure, from compelled disclosure, the way communications with a lawyer is. But nevertheless, I am trying to use my advocacy skills to do persuasion, to secure a social justice goal. Let me turn briefly to the importance of nonpartisanship. This is a core message that will again pervade these talks. My mantra, since I got involved in community social justice advocacy as a volunteer activity outside my day job, and now as almost a full-time activity, I am nonpartisan. I'm not a member of a political party, though any number of our supporters are. I am not campaigning for any political party or against any political party. Some people find it attractive to take their social justice advocacy goals and efforts and turn it into a campaign to defeat any particular party that they or leader that they think is hostile. And I'm not advocating or editorializing on their activity. Everybody does this the way they see fit. Let me tell you why I stick to nonpartisanship. I find that if you tie yourself to one party or against a particular party, you are at huge risk while doing this kind of advocacy of having other parties write you off. If you campaign to get a particular party either elected and defeated, defeated, and they win the election, well, they're not going to listen to you for the next 4 years because they see you as a constituency that was advocating in a partisan context to defeat them. But if you campaign for a party and they win, you also have a certain vulnerability. And that's because once they win, if they think of you as within their fold, if you will, and having campaigned against their opposition, they may well discount what you say. Oh, they'll invite you to the room and try to tell you you're very important and all that stuff. But they will think to themselves, hey, these folks have nowhere to go. They're in our tent. And so we can actually treat them as not as compelling a source of advocacy as we might from a sector of society that is in play in terms of their message. I believe that it's vital for us to be able to work, for me at least, it's vital to be able to work with all political parties, whether they are ones I agree with or I don't. In fact, it's none of their business how I vote or whether I vote. And I think it's especially helpful to stay nonpartisan because in any social justice advocacy, you want to build as broad a base of supporters as you can. If you are identified in connection with as supporting or opposing a particular party, then the party you don't support or you're seen as explicitly hostile to, their supporters won't want to get anywhere near you. On the other hand, when you're nonpartisan, you are in a better position to approach supporters of whatever party you want and try to get them on side and try to get them to work within their parties to move them in direction of the platform that you're advocating. So what does this mean, nonpartisan? It means we explicitly, the coalition I serve, doesn't try to elect or defeat anyone. We don't tell people who to vote for. What we do is we try to get the strongest election commitments from parties. We try to let the voters know what the different parties have committed to. More about that in a future lecture, but how to do that. But generally, we operate on, and I especially operate on the premise that politician does something that's good for us, we got to applaud. Maybe in a politician you like personally, maybe someone you can't stand, but doesn't matter. That's nobody's business. Nobody really should know. It's simply a matter of if they do something good, we applaud them. If they do something bad, we criticize them and we make constructive recommendations on how they should improve. I am happiest when they know well what we want and what we will approve and what we won't approve. I was delighted once when a particular minister's staffer told me, sort of kidding, but not really, Lepofsky, you are really predictable. Well, I like that. I want them to know if they do something, I want them to be able to count on us and count on me that if they do something that we support, we're going to give them legitimate credit. And if they do something that we really don't like, I want them to know in advance that they're going to be criticized for it. And why? That is, to me, the best formula for being able to get the most success in this kind of advocacy. Let me conclude this introductory talk by telling you that I find this kind of social justice advocacy very rewarding. And I've had what I consider to be a very enjoyable, challenging, and beneficial career in traditional law practice. Some of the moments I've done as social justice advocacy eclipse some of the most exciting moments I've had appearing in the Court of Appeal in Ontario or the Supreme Court of Canada arguing a tough case. And I love doing that. It is vital doing this social justice advocacy. We must stay optimistic. The odds could always look like they're basically hopeless. That never stops me. My view is that just challenges me to move and do better. It's our goal to be optimistic individually and to be optimistic and to share optimism and generate optimism on the part of our the community for which we're doing advocacy. My biggest advocacy success in my career happened to have come 45 years ago in 1980 when I, working together with a number of other people, we collectively won an amendment to the Canadian Charter of Rights, then just a proposed Charter of Rights, to include equality for people with disabilities in the Charter. That is the story I cover in my memoir. And I called it Swimming Up Niagara Falls because by any objective measure, what we tried to achieve was obviously hopeless. We had no hope, and yet we succeeded. It's vital to undertake these kind of activities as an optimist, no matter what the odds appear reasonably to be. We don't do social justice advocacy because it's easy. Uphill is where we live, and that's just the way it is, and it makes it, once you accept that, once you're ready to work with that, it makes it enjoyable to engage in this kind of activity and rewarding whenever we make progress, whatever that progress may be. I once had a nosebleed when I was about 10 years old. I'm totally blind now, but when I was a kid, I was nearsighted. I could read if I held a book close to my nose. And that nosebleed really transformed how I see this kind of advocacy. I was swimming in a swimming pool, and I accidentally swam face first right into the side of the pool. My nose bammed into the wall. I stood up, my nose was throbbing. I held my hand out under my nose, palm up, and I had a look of horror on my face. Somebody saw me and they said, they saw that I looked horrified, and they said, David, don't worry. It looks like there's a lot of blood in your hand, but there's only a couple of drops of blood that fell out of your nose. When it hits the water, it looks like a lot of blood. Why is this my guiding light? Because in doing social justice advocacy, we may only be able to produce a couple of drops of blood. No, I don't mean actually physically hurting anybody. But my goal is to make the target of my social justice advocacy and our collective advocacy, make them feel like it's that handful of blood. Oh my God, it's way more than I thought it was, to magnify our impact. Now, when I talk about advocacy and dealing with the feeling of swimming up Niagara Falls, I invite you, if you engage in social justice advocacy, to think about the experience of chopping down a tree. Now, what am I talking about? Well, I can tell you my environmentalist buddies don't like when I use this, but if you try with your hands to push a tree over, a big tree, you can't budge it. If you got an axe and you swing it as hard as you can, just once, you'll make a little dent, won't make a difference. But we know that if you swing that axe enough times, that you can chop down a tree. We know that if two of you swing axes and don't swing them at each other, but work in harmony, you can chop it down maybe twice as fast. My contention is advancing a social justice advocacy is just like that. Our goal is to empower people with individual actions which are like individual swings of the axe. Each one of them may feel like you're just making a little dent, but together they'll bring that tree down. Thank you very much, and looking forward to you coming back for the second lecture.